On January 11, 2026, in a Texas family court proceeding, Judge presided over mayoral county cause number 320-26-5C, a child custody matter involving Jermaine Tiles, an incarcerated father, and Vanessa Lopez, the mother of their children. The case centered on a motion to enter a final order converting temporary custody arrangements into permanent orders, including provisions for supervised visitation and retroactive child support. Beverly Sparrow served as the attorney ad litem representing the children's best interests, while the Texas Department of Family and Protective Services sought judicial approval to finalize the placement.
At this time, court's going to go ahead and call Bell County calls number 322,265-C. This is in the interest of Kyle's minor child. Non-custodial party is Mr. Jermaine Kyle's custodial party is Vanessa Lopez, and the AP in this matter is Beverly Sparrow. Anyway, this matter is before the court on a motion to enter order. The court has heard from the Ms. Gustafson, who's approved of entry of the order and signed off on it at this time. The parties that are present are again Ms. Lopez and Ms. Burrell. Mr. Cowles is incarcerated. So at this time, I'll ask the state for an opening to tell the court. The court understands that the state's requested the entry of an order, and I'll ask the state to make an opening whether or not he knows whether either party is in objection to the order as is, and what those objections are, if any, and then we'll get some testimony from them to confirm that. So at this time, you may proceed, Mr. Coates. Thank you.
Thank you, Your Honor. Your Honor, the state has completed an order that conforms with the court's ruling at the last hearing. Essentially, we transferred what were temporary orders into the final order with some provisions regarding visitation and access, and then the addition of a retro finding against Mr. Kyles. I'm not sure if Ms. Lopez and Ms. Farrell have had an opportunity to review their email, but I would let both those folks know there's a order that's been circulating for your signature and approval. I don't know, based on the last hearing, of any problems or concerns about the proposed order. And certainly my hope is that Ms. Lopez and Ms. Farrell will be in a
I had no problem with the order. I do know that Miss Lopez had concern about money that had been withheld that she had not received, but it's my understanding they needed an order in order to send the money to Miss Lopez. And so I think if the order is signed, that will solve her problem.
Okay, Ms. Lopez, the norm is that, yeah, that they need a court order before any monies can be released. And I'll allow you and Ms. Farrell to make ask any questions at this time, or tell the court why you're in agreement or not in agreement with the court signing this order and getting those funds over to you, or being sent out one way or the other, or whether or not you had a specific problem with the order and had a chance to review it. Technically, you're both your own representatives. And so, Ms. Lopez, have you received a copy of the order, or had a chance to review it, and tell the court what you want me to do?
I'll agree to whatever's on the order because I have no problem. Beverly Sproul has been helping me a lot with the girls. So whatever Beverly agrees to, I agree to.
All right, then. So again, obviously the state's prepared to send it over. So, Ms. Farrell, do you have any objections, anything at this time?
As long as I'm not paying him any money, I don't care. He don't need none of my money.
There you go.
If
I
he
did have a lot of
takes
people
any of
that
my money, we have a whole problem.
Well, man,
The court conducted a hearing to convert temporary custody orders into a final order, with the incarcerated father absent and the mother and caregiver expressing agreement. The judge ensured both parties understood their right to self-representation and confirmed their consent on the record before approving the order under the Texas Family Code Section 153.001. The primary consideration in any custody proceeding is the best interest of the child, which requires courts to evaluate stability, parental fitness, and the child's emotional and physical needs when establishing permanent conservatorship. Section 154.009 specifically addresses child support obligations of incarcerated parents, permitting courts to order retroactive support when the parent's incarceration resulted from criminal conduct rather than involuntary unemployment, ensuring children do not bear the financial burden of a parent's criminal choices. Additionally, Texas Rule of Civil Procedure 11 requires that agreements affecting child custody be in writing and signed by the parties or their attorneys to be enforceable, which explains why the court insisted on formalizing the parties' oral consent through a written order despite their apparent agreement. Here, the court applied these principles by converting temporary orders to final status with retroactive child support against Mr. Tiles, presumably based on findings that his incarceration stemmed from criminal conduct rather than circumstances beyond his control. The judge's careful questioning of Ms. Lopez and Ms. Burrell, confirming they had reviewed the order, understood their rights as self-represented parties and voluntarily consented, satisfied the procedural safeguards of Rule 11 and ensured the final order would withstand appellate scrutiny. The court's handling of the withheld funds also demonstrates how final orders trigger administrative mechanisms for distributing child support arrearages that accumulate during temporary placement periods. This exchange illustrates how family courts balance efficiency with due process. Parties can reach agreements, but judicial oversight ensures those agreements truly serve children's interests and that unrepresented litigants understand what they're consenting to. Without such procedural rigor, vulnerable parties might unknowingly waive critical rights, and children might lose access to support they're legally entitled to receive.
There's a lot of people that don't need my money, but they sure as heck taking it. But the bottom line is,
Tell me about it. Tell me about it, because I pay my child support. Okay, so I'm tired of them trying to give my money to him.
okay, well, they're going to give it to
He
them.
don't even
Obviously,
take
it
care
goes
of
to
a
Ms.
kid.
Lopez, ma'am. So, again, that new order will take care of that. So, do you have any objection to me signing off on it?
No, sir.
All right, then, everybody, I'll sign off on it. So, the ad litem has already done it. Mr. Coates, I'll have you circulate that. Send a copy to the parties again. Just make sure they got it. But go ahead and send it over to me for signature, and I'll sign it without their signatures because everybody's in agreement on the record.
Thank you so much, Judge. And before we part ways, Ms. Lopez and Ms. Sproul, please check your emails. It'll come to you first, Ms. Lopez, and then to Ms. Sproul for signature on the order, okay?
Okay. All right.
Okay. Thank you,
Yes, sir.
ladies.
Thank
You're
y'all all very much.
welcome.
Everybody be safe out there, and hopefully it won't be 100 degrees today and 32 tomorrow, but
Oh,
we'll
Lord.
see.
All right. Thank you,
That's
Your
what you
Honor.
get when you live in Texas. You never know what you're gonna get.
Well,
Yes,
lately,
indeed.
my college roommate's an MD in New York City, and he's had 3 snowstorms this year, so I'll live with Texas for now, okay?
That part. Look, thank you.
Thank
I'm with
y'all.
Thank
you.
you.
Thank you.
Thank you. Bye-bye.
Your Honor, may I be excused?
Oh, yeah. And of course, my college roommate decided to get married a third time, and now he's got 2 10-year-old boys running around. And
Ooh.
and he said they're snowed in, and he's not happy. So, yeah.
I know that's right. I would be like, go get a job. Let me stop.
But 10-year-olds
No.
don't like working, and they say they figure if dad's an MD, dad can bring home the bacon and take care of everything. Okay.
Oh,
That's mama.
I was
That's what
like, that
mama's
sounds like
doing.
me. That's
That's
me.
mama doing that. She's bringing home the bacon. Take care of
There
her
you
little
go.
babies.
Thank you, ladies. Y'all free to go. Thank you.
Okay.
You
Thank
too.
you so
Thank
much.
you. Have a great day.
You too now. Thank you.
Bye-bye.
Yeah, I just
Me neither. I can't do this self. Oh, I'm so old school. Lord, help me, Lord. Take this up. Every says turn.
that's that. See, now you sound like my mom. No problem, ma'am. Is anyone here on the second one, Mr. Coates?
Your Honor, yes, sir. The CP is here, and again, she had reservations, but I guess we should just hear what they are. And I've got the order drafted, and I've signed it, so we'll just she didn't want to sign it. I think
Okay, we're doing the order suspending.
I submitted it to the CP for approval through DocuSign, and she wasn't ugly about it, but she didn't want to do it. So we'll just see what's going on.
All right, is she in the main room? She in the breakout room now?
Yes, sir. She's in room 10.
You want to bring her on over, please?
Can I do that or?
What's her name again?
After the parties confirmed their agreement, the judge approved the final order for signature without requiring simultaneous physical signatures, instead relying on the record of oral consent and directing subsequent electronic execution through DocuSign. Texas Rule of Civil Procedure 306A 5 permits courts to sign judgments based on agreements announced in open court, with formal execution to follow, recognizing that practical constraints, particularly in remote proceedings, should not impede resolution when parties' consent is clearly established on the record. The Texas Supreme Court's 2021 standing orders on remote proceedings, extended and modified through 2026, explicitly authorize electronic signature platforms like DocuSign for court orders, reflecting pandemic-era innovations that have become permanent fixtures of judicial administration. Furthermore, under Section 153.0071 of the Texas Family Code, mediated settlement agreements and collaborative law settlements receive heightened deference. But even informal agreements announced in court bind parties when the record demonstrates knowing. Voluntary consent here evidenced by the judge's detailed questioning and the parties' unequivocal statements. The judge's decision to sign it without their signatures because everybody's in agreement on the record operationalizes these rules. The oral proceedings created an immediately binding judicial determination, while the subsequent DocuSign circulation provided the documentary form required for enforcement and administrative processing. This sequencing, judicial approval first, party execution second, protected Ms. Lopez's interest in receiving withheld funds promptly, while preserving the formal requirements of Rule 11. The court's direction that Ms. Lopez receive the document first. Then Ms. Sparrow also suggests attention to hierarchical signing protocols that reflect the custody arrangement structure. This procedural flexibility matters enormously for low-income litigants who may lack consistent access to technology or transportation. By separating judicial approval from documentary execution, courts prevent procedural technicalities from defeating substantive agreements. The approach also demonstrates how family courts have permanently integrated remote technologies, ensuring that incarceration, geographic distance, or resource constraints do not bar access to justice. The court signed the final order converting temporary custody arrangements to permanent status, incorporating supervised visitation provisions and retroactive child support obligations against the incarcerated father. Ms. Lopez and Ms. Sparrow were directed to execute the order via DocuSign, with distribution of withheld child support funds to proceed upon finalization. The parties were excused, and the court proceeded to the next matter on its docket. This case exemplifies a fundamental tension in family law. The state's parens patriae power to protect children must coexist with constitutional protections for parents, even those whose circumstances, like incarceration, limit their ability to participate. The Texas Legislature's 2023 amendments to Section 153.074, which clarified that incarceration alone does not constitute a material and substantial change warranting modification, reflect growing recognition that parental rights endure despite criminal punishment. Yet courts retain authority to establish support obligations and visitation frameworks that acknowledge practical realities while preserving future reunification possibilities. The procedural innovations on display, remote appearances, electronic signatures, record-based approval demonstrate how family courts have evolved to serve families in crisis without sacrificing the deliberative processes that distinguish judicial from administrative decision-making. For viewers, this case illustrates that family court is less about declaring winners than about constructing durable arrangements that can adapt as circumstances change, always with the child's welfare as the pole star. If you're facing a custody or support matter, remember that agreements announced in court carry real legal weight. Understand what you're consenting to before you speak. Research your state's rules on self-represented litigation, and consider consulting with a family law attorney or legal aid organization to ensure your rights and your children's interests are fully protected.